All right, great. Welcome back, everyone. Well, the bad news is that it's 18 degrees and sunny in March here in Toronto. The good news is we are all together here on Zoom together for another great panel. So looking forward to this. We've got 6 terrific speakers with different perspectives coming onto a panel which has been called Artificial Intelligence and Human Rights Protections. Again, my name's Trevor Farrow, and I'm going to act as the chair for this panel. And I'm going to take a page out of Professor Chaudhry's book. I'm not going to introduce everyone. The bios and what have you are in our program. So we'll just get right to it so we can maximize our discussion and time for Q&A afterwards. So with that, I'm going to start in order of our program and start with Professor Sean Rehaag, my colleague from Osgoode Hall Law School. Sean, over to you.
Hi, everyone. I'm just going to share my screen here. All right. So I'm Sean Rehaag. I'm the director of York University's Center for Refugee Studies. I'm also the director of the Refugee Law Lab, and I'm a faculty member at Osgoode Hall Law School. I wanted to begin just by recognizing that this conference is occurring during a labor disruption at York University. I wanted to send a shout out to workers that are part of QP 3903 and to call on York University senior management to negotiate in good faith so that everyone can get back to work. So what I'd like to do this afternoon is to talk a little bit about some opportunities that I see for rights-enhancing uses of artificial intelligence in the border control space. Might be a bit surprising that I'm going to talk to you about that because many people who work in the border control space are highly concerned about the ways that technology and artificial intelligence are used in ways that undermine basic human rights, and including the right to seek asylum. And you can think of lots of good reasons why people might be concerned about that. Here I've put up an image of some robot dogs that Department of Homeland Security is using to monitor the US-Mexico border and to track down asylum seekers. Imagine that you're trying to seek asylum in the United States and one of these things comes running at you. It must be quite frightening. Here's another example in the European Union. They've been testing out video kiosks where travelers who are seeking admission to a country engage with a video kiosk, and the purpose of that engagement is that there's AI that's used to detect whether the would-be traveler is lying. So it's kind of lie detection software. It's known to be biased against anyone who's not a white man, for example. Here's another example from Canada, the Canadian government using photo matching technology to try to catch fraud in the immigration space. There's been litigation on this question, and courts have found that the technology that was used was not transparent and was potentially biased. So in this context, many observers are raising really serious concerns about the use of technology and artificial intelligence in particular in the border control sphere. Petra Molnar, who's the Associate Director of the Refugee Law Lab that I run, is one of the leading thinkers on this, and here are some examples of her work that tries to set out human rights critiques of these technologies. But what I want to do this afternoon is to show you the flip side of that, because I do think that there are some human rights enhancing opportunities for using this kind of technology, and I want to make a pitch for why we should embrace those opportunities. So to do that, I want to talk a little bit about some research that I've been doing for quite some time. So back in 2012, there were concerns expressed by lawyers about Federal Court of Canada decision-making in applications for leave for judicial review in the refugee law context. And specifically, immigration law is unusual in the Canadian context in that you don't get a right of access to the court. You have to ask for leave or permission from the court for the court to hear your application for judicial review. No reasons are provided if leave is denied. And lawyers were raising concerns that these decisions were arbitrary and kind of came down to which judge decided the case. So I decided that I would do a research project that would look into this question. And there are no court decisions involving leave decisions because no reasons are provided when leave is granted or denied. So you couldn't use standard legal methodologies, kind of reviewing court cases to see what the relevant legal norms were. So what I did is I went onto the federal court website and I noticed that there is a court docket for every single proceeding before the federal court. And you can see an example of the court docket on the PowerPoint presentation here. And what the court docket does is it just sets out a sentence about every step in the process. Could be the application was filed, and then the respondent filed materials in opposition, and then there was a leave decision, for example. And these are written in natural language. And so what I did is at the time, I was a kind of amateur computer programmer. I enjoyed playing around with code in my spare time. And I wrote some code to go and scrape all of the decisions, all of these dockets from the federal court website. And then I amassed a team of about a dozen research assistants who manually went through them and gathered data points from other dockets, including whether the application was perfected and whether it was a refugee, a judicial review, and who the judge was and what the outcome was. And using that methodology with a couple thousand hours of research assistant time, I put together some statistics on outcomes in leave applications in the refugee law context. And you see some stats on the PowerPoint here showing that from the period, I think this was 2005 to 2010, if Justice Campbell was the judge who was deciding your case, you were granted leave in over 75% of cases, whereas if you had Justice Crampton, it was like a 1% chance of success. And remember, these are non-transparent. You don't get reasons. You can't appeal the decisions. And so this, I wrote a law journal article about this, which generated quite a bit of attention. The federal court responded, recognized that there was a rule of law problem here, and set out in a strategic plan some measures to try to improve decision-making in this area, to try to increase consistency in decision-making. Then I ran in to Justice Crampton, who became the Chief Justice of the federal court. He recommended that I redo the study to see whether the efforts the court had made had improved things. The idea of going out, getting another dozen research assistants, training them, spending hundreds of hours of my time and thousands of hours of their time to go over tens of thousands of dockets didn't appeal to me. And so I decided to improve my coding skills and use rules-based artificial intelligence to try to extract data from these natural language entries in federal court dockets. And so I took advantage of things like often there's the word grant or denied application for judicial review in particular places. And if that phrase is there and the name of a judge from a list of judges that I have is there, then infer a particular outcome. And so I created a set of rules, hundreds and hundreds of rules, tested them against the data set that I had put together for the first study, and then tested them on new data, got up to like 98, 99% accuracy, and used that data to redo the calculations. So instead of having thousands of hours of RA time, I had hundreds of hours of my time doing coding and a few hours of RA time to put together some verification data. And what did that show? Well, it showed that very little had changed between the period of the two studies, that it continues to be the case that if you're lucky in which judge hears your case, you will succeed with your case. And if you're unlucky, you will not, with success rates ranging from the single digits to over 50%, depending on the judge. More recently, I was on sabbatical. I decided I wanted to do this similar study again, this time about a different process, not leave applications, but stays of removal. The last step before you're removed from the country, you go to the federal court and say, temporarily stop my removal. Lawyers had raised similar questions about fairness in these processes. So I was on sabbatical last year. I decided that I didn't want to spend the hundreds of hours that I'd spent doing the coding to this study. And so I used generative AI. This was pre-chat GPT. So I was using fine-tuned generative models. And these fine-tuned generative models were more accurate than my rules-based AI coding, and they were more accurate than the human JD research assistants. And what did the study show? Well, it showed that outcomes hinged on who the judge is, that if you had Justice Neer deciding your application, you were not going to get a stay, whereas if you had Justice Campbell, you probably would get a stay. So what do we do with this? Well, I think that one of the things that we can do is that we can see that technology, coding, artificial intelligence is becoming easier and easier to use, and it can be used to turn scrutiny onto decision makers. And so I've got this project called the Refugee Law Lab portal. You can visit it at rllp.ca, which takes some of the research that I've been doing using these technologies and tries to visualize them so that lawyers and people appearing before immigration decision makers and federal court judges have information, actionable information that they can use to drive their strategic decision making. So if you're in a refugee claim, you know that you have no chance before a particular decision maker. Your job as a lawyer is to generate a record that's going to be useful on appeal or on judicial review. Whereas if you have someone who's more likely to grant the refugee claim, maybe you kind of take more of a hands-off approach and let the process run its course. Another example of work that we're doing at my refugee law lab is that we're concerned about privacy in the refugee law context, with refugee law decisions being available online. And we've been working with AI-based systems. Here we were using a flavor of BERT called Roberta that creates automated redaction processes to try to improve privacy. Finally, my lab has been doing work trying to make legal data available to the public to create the kinds of tools that we've been creating. And so if you're interested, you can go to the Refugee Law Lab website. You can, with one line of code, download all Supreme Court cases or all federal court cases and use those in generative AI systems. So I'm going to end with a couple of observations. First, I think when we're thinking about AI in the legal context, it's very important to start with the presumption that human decision-making is not perfect, that it is flawed, that it is often a black box, it's often non-transparent, there's often biases, it's often inconsistent. And those are complaints that we make about generative AI, but we should make those about human processes as well. Second, I think it is possible to produce technologies that will be rights enhancing. We can shine scrutiny on decision makers, not just on applicants for refugee protection. We can choose, for example, to invest in drones to save lives when people are in transit trying to cross the Mediterranean rather than drones to block asylum seekers. We can choose to create technology that tries to identify racial bias among border officials rather than trying to identify fraud in immigration processes. And so that's my last point. The problem that the issue with generative AI and other forms of technology in the border control space is not the technology, it's the choices that we're making. And so I'll leave you with the pitch that I think we should be making better choices.
Great, Sean. Thank you very much for starting us off. Terrific. And I know there'll be lots of questions as we get going. We're going to just keep moving through our terrific lineup, and I'm going to next go to Professor Jake Effoduh, and who's going to look at how artificial intelligence and bastardizing paradigms of human rights in the third world. Jake, over to you. Can't hear you yet. Whether you're on mute, I'm not sure.
Can you hear me now?
Yep, now I've got you.
Thank you very much. Can you see my screen as well?
Yeah, I can see your screen as well. So I'll pop out and then I'll come back when time's up.
All right. Thanks so much, Dean. I would like to thank the Nathanson Center for putting together this very relevant and timely conference, and to appreciate you, Dean Farrow, Professor Chowdhury, Professor Velario, and Leo for all the work that has led up to this. I think it's such an honor to see and listen to all the renowned scholars here, many of whom I've admired for years and whose work I'm inspired by. I feel really grateful to be on this panel with the amazing Professor Sean, Professor James, Dr. Anthony, Director Thomas, and fellow Osgood PhD candidates, Alexandra and Luna. And I think just leading up to what Professor Sean said about AI technologies disenfranchising certain populations, it's important to recognize that it's mostly the most beaten down by society that gets quite implicated in this process. And we've seen two cases here in Canada. I think there's Barry versus Canada and AB versus Canada that shows how AI systems, misidentified several Black immigrant refugee women from Kenya, and from Somalia in such a way that their refugee status were actually quite revoked. But anyways, I would start by introducing myself. I am currently doing my PhD here at Osgood Law School, but recently just started as an assistant professor at the Lincoln Alexander School of Law. And in the last 5 years, my current PhD studies has involved leading and researching across 16 sub-Saharan African countries, investigating how AI is being legitimized in the region and the potential for it to sort of cure the popular legitimization crisis that activist forces face in the region. And so looking at this quote by Stephen Jay Gould, recognizing that what has changed with AI is something that is not only unprecedented, but we kind of lack the potential to be able to address this. I witnessed how the use of AI in 3 of the highest AI deploying countries in Africa, Nigeria in the West, Kenya in the East, and South Africa in the South, is transforming both the conceptions and practice of human rights in the region. And that is what led me to offer to speak about this topic, albeit very concisely. So quite unrelated from my PhD, but the experience of which accorded me the insight to speak on how AI is bastardizing human rights paradigms in the third world. So I'll quickly just go through a few clarifications, talk a bit about how the universal paradigm of human rights has been replicated by a trade-related market-friendly one, and then, of course, make some examples around the unintended consequences of AI altering these paradigms of human rights in sub-Saharan Africa. I like to make some clarifications of concepts, because when we talk about AI or human rights, I don't think we all speak about the same things. So it's important to recognize that I don't need to espouse on the concept of AI, because AI is pretty much language du jour. It's a popular anthem now. It's almost like a religious recital. Everybody attaches AI to whatever that they're doing. But in recognizing that AI is not just a set of computer techniques or some data-driven automation, but is actually a constellation of processes and technologies, language and culture, as defined impressively by the UN in 2021. But as per critical AI scholars from the Global South, we need to look at this technology as a tool that commodifies social relations, that annexes data to capital, that colonizes human lives by yielding unequal social and economic relations, and widening the digital and developmental divide. And if I may add, is also mutating conceptions of human rights. Of course, with a proviso, right? That AI has immense, beneficial, transformational value. It's fantastic, it's metamorphic, but it's definitely not universal, and it's conversely for some. And I'm using bastardizing or bastardization, which I know is quite razor sharp, but I'm not using it here in the literal sense, but in the metaphorical or analogical sense, which is quite known in legal scholarship. Like legal theorists such as Richard Posner talks about how legal interpretation can give into a distortion of sound legal arguments. Or when we look at how Patricia Williams sort of criticizes the tools that we use in the way that they can bastardize or perpetuate inequality in terms of race, gender, or class. We can also rely on Martha Mino, or we can rely on some Black queer scholars like Bell Hooks or James Baldwin that talk about bastardization in the forms that they subjugate subaltern norms. So this is how and why I'm using this term as a critique of legal reasoning and interpretation to analyze the power dynamics for how this sort of bastardization or corruption or distortion or current displacement of human rights paradigms from an already troubled universal one to a more economical, informational one that imposes human suffering in the sub-Saharan African region in the ways that we see it happening today. And of course, the conceptions of human rights is quite broad, it's very known, but it's important to appreciate that beyond the foundational understandings of what we understand human rights to be, beyond the philosophical traditions, beyond the historical developments, beyond the geolegal contingencies, this concept of human rights is not free from criticisms and ambiguities. So when we need to appreciate this conception, we need to see it from a more expression of political claims as practices, which is highly contested, including with the age of AI today in the ways that we see it happen in literally every sense of the word. And when I talk about the third world, yes, I sort of locate myself within sub-Saharan Africa and the 16 countries that I'm conducting my studies on for my PhD. And people argue it's an outdated term. It alludes to some dichotomy between regions of the world. But I use it here to enhance the techno-legal relevance of the digital AI divide and to advocate for an inclusive critique of the way that we see the shiftings of human rights norms and practices to accommodate views of the majority region. So scholars like feminists such as Joy Bulwamini, Timinit Gebru, they talk about the third world as an undersampled majority when it comes to the way that they're marginalized by the AI industry. So let's talk a bit about what I've experienced from above. And by above, I mean by the states within the African sub-region where the inability to address human rights issues that comes from the use and deployment of AI systems is accruable to some examples, such as the fact that 6 of the 16 states actually believe that a lack of legal legitimacy is actually a good thing in the sense that it would help promote innovation. And it's important to note, just like Professor John Penny said earlier in the day, and Professor Sean as well, today the EU AI Act got passed with 523 votes supporting it, 46 against and 49 in abstention. And it's appraised as one of the strongest legislations to sort of like govern AI globally. But the EU has no relevance in such a way that if anyone from the EU goes to Africa and use AI to perpetuate harms, there is no obligation in that regard. Canada's AIDA does not also impose any obligation on like Canadian developers who use AI systems in the region, recognizing the fact that 25% of the AI systems used in sub-Saharan Africa are of Canadian origin. And of course, if we can't look to the EU or to Canada, we definitely can't look to the US, to China, and other jurisdictions as well. But the other thing is, when you look at the trajectory within which African states are following, this narrative in terms of let's favor AI, let's favor innovation, is one that tallies with Upendra Baxter's point about how new technologies tend to coerce states towards deregulation. Because they use their power and their influence. And that has been quite evident in 6 African states shutting down any regulatory sort of potential to mitigate the harms that AI might perpetuate when it comes to human rights. And of course, the second would be this branding, this so-called branding that, you know, AI is sort of legitimized as for social good, is for the well-being of everyone, seems to be sort of selling its point within the region whereby people have claimed AI to have legitimized itself. This expression in Africa that, you know, goodness should flow uncontained by the fences of permission. And so therefore, this type of marketing rhetoric is also evocative of this signal, this transposition, this bastardization towards a new era of globalization with AI, where systems of global capitalism are now sort of masked in an attractive language and promise that feign goals in such a way that causes human rights and human rights for all. But research has shown over and over again that the biggest harms from AI systems have occurred on the African continent and have affected African people and people of African origin more than 16 times over any population existing globally. And the third point, of course, is about the deterritorial weakness and the inequality of bargaining power. Nigeria is looking forward to Canada's legislation to see how it would sort of maybe copy from that. Kenya is looking more to the US. South Africa is looking more to the EU to see how these jurisdictions might influence or inform the ways that they sort of govern, or the frameworks that will govern the use of AI to protect human rights within the region. And I think this quotation, which I wouldn't read, helps me make the point about how African states from the top are sort of more soft, as like smoothies towards global AI capital, but are really hard towards the human rights infringements that these AI systems have sort of taken over within the region. So when we look at from the top, we can see how Upendra Baxter's germinal theory on the supplantation or the bastardization of a universal declaration of human rights into this new trade-related AI market-friendly discourse, reinterpreting human rights in such a way that the concepts and the revisions when it comes to how we see the history of how we practice human rights, how we understand human rights, are sort of placated into these ideations of AI modernism, into new identities and institutionalisms affecting almost the poor and the vulnerable within the region. And so we see how that bastardizes from the top. There's also some form of bastardization that goes on from below, in such a way that despite not having any laws that sort of produces liability to AI companies or even to the government or to people who actually maliciously use AI systems, we see that there's a bastardization taking place even from below. And I use these 3 examples just as a very small snapshot. During my research, I interviewed over 65 AI experts. I met with over 2,250 local respondents who surprisingly use AI tools in their work. A few among them are, you know, the bureau de change dealers in the capital of Nigeria who use an AI application to determine black market exchange rates and forecasts via a computer application feature. We also see how dairy farmers in Kiambu County in Kenya who use AI systems through a machine vision and image recognition software to detect diseases in cows and suggest treatment options. I mean, that's great. No one is ever going to say that's not a great thing. There's also the gold miners in Witwatersrand Basin of South Africa who use an integrated system of sensors to monitor the structural stability of the mines, and also algorithms that can help them analyze both sensor data and equipment data so they can flag potential issues, thereby improving deep mining optimization and safety. Any of the Nigerians here on the call will recognize that the bureau de change dealers have experienced 16 times changes in terms of regulation from the central bank and from the government in the past 5 years, attacking the bureau de change dealers as though they are the reason for the economic downturn. But what no one is looking at is how these bureau de change dealers, the very elite ones, are relying on AI tools and systems which are not developed in the region for the region and have been influenced by certain external Western factors that are literally implicating the outcomes for their work and removing some of them out of business with no call for any liability or remedy. The same thing happens with the dairy farmers in the Kiambu County. who now see their, local cows as sort of quite different from what they know them to do. I mean, if you go to Kiambu County in Kenya, the cows you will see there are more of the Boran and the Sahiwal breeds. And so the image vision machine recognizes these cows to be misdiagnosing them to have some form of disease or that they're malnourished because they don't have the, in quote, optimal weight template in the platform that it uses to recognize them. So these local farmers, their cows are not like the Holstein breed or the Angus breed that we're quite familiar with, which are most likely bigger and can be used to sort of, breed for meat and dairy, but they're actually quite smaller. And in this case, apart from the fact that this is causing a kind of stifle in terms of how they treat their cows, it has also removed the local veterinary medical practitioners out of business. The same thing happens with the gold mines in the gold mine in South Africa, where 6 months ago, 24 of these miners, in terms of the miscalculation from their system-censored device, caused the death of these individuals with absolutely no liability and no cause for repercussion for how these AI systems misread the inputs in this regard. So I know I don't have much time and my time is pretty much up, but the point I'm making here is the combination of these alterations, be it from above and from below, is what I theorize as bastardizing the conceptions and practice of human rights in the region, despite the fact that there are still these forces acting strongly, and more than 92% of the AI software used on the continent are literally exported and even honed from abroad. Canada has a Canadian Pan-AI strategy that recognizes the African region, but it doesn't look into how this displacement occurs and how we can do certain things to remedy the situation. Thank you very much. I look forward to the Q&A.
Professor Effoduh, thank you so much for taking us through that. I'm now going to shift gears and move to our colleague, Professor James Sheptycki, and discuss a Canadian perspective on excuse me, on AI and the Police Intelligence Division of Labor. James, over to you. And we see your slides coming up. I haven't heard you yet, but we do see you putting your slides up.
Sorry about that. I'm having some difficulties figuring out how to share my my slides. There they are. Start. Can you see that?
Not yet. We can certainly hear you, but we've still just got the gallery view in Zoom at the moment.
Oh, share screen. Desktop. I do apologize.
There we go. We've got your desktop, which has numbers of things open and the slides sort of on them. If that's where we get to, maybe that's the best we do, but they're just not maximized is the only thing.
Yeah, what I'm going to do is play from the start. How's that? Can you see?
Go. Yeah, got it. And I will pop back just as we're at the end of the time.
All right. Thank you very much. And thank you, everybody, for showing up, and to the organizers for putting all of this together. I have to say that I found the whole experience incredibly stimulating and thought-provoking, almost too much so. I've been retired now for some time and living in a log cabin on the West Coast, a rather hermit-like existence. I'm not used to interacting with so many brilliant people And you all talk so fast. It's amazing. I'm just not used to it. So today I want to take the opportunity to share some ideas and thoughts that I've been working on. I've just come to finishing off a piece of writing with the title Technopoly, Techno-Policing and Social Order, which is kind of what I'm going to be drawing on today. So apologies, but I'm sort of rehearsing some ideas that have been rattling around inside my own head, and I haven't had an opportunity to test drive them on an audience. I'm a little nervous about doing that. Just to point out that part of my slides will list publications, previous published work that reflects on some of these issues, so people who are taking notes and want to follow up with further reading can do so and add these to their bibliographies. Just to explain and introduce myself, I'm a sociologist, not a lawyer. The difference between sociology and law, I think, is important. It is this: both law and sociology claim a kind of omnicompetence, which is to say that there is no facet of human life and experience that law can't claim to overview. And it's the same with sociology. Sociologists can theorize and study every aspect of the human life and human experience. But there's a fundamental difference between the discourse of law and the discourse of sociology, because law is a language of power and sociology is a language about power. So I'm obviously a weaker participant in these dialogues than the lawyers that are present today. I'm an ethnographer, and my tribe, so to speak, are the police. And I would just like to emphasize that as a police ethnographer, I cultivate the viewpoint of an insider-outsider. I spent my career getting into police organizations so that I could see what the world looks like from inside the police institution. But I'm obviously an outsider. I'm not a police officer. I'm just there to appreciate what police work looks like from the point of view of police workers, and try and give some account of what it looks like from the inside to outsiders who don't have the benefit of getting inside these very secretive organizations. I think it's helpful to have some kind of definition, definitional ground on which to stand. What is it that I'm observing when I talk about police work? Now, the definition that's on the screen here is a synthesis from many, many other works by police sociologists over decades. So it's not just something that's emerged from my own work. It is a synthesis of the scholarly work in the area. The police métier, the police profession, what it is that police do, well, it involves two things. On the one hand, it involves the techniques and powers of surveillance, keeping watch, unending vigilance, coupled with the power of coercion. And police work involves the use of surveillance and coercion in the pursuit of police organizational goals, which are reproducing order, making crime, managing risk, and governing insecurity. The police métier has two aspects. It has a technique, a set of techniques to master, the techniques of surveillance and coercion, and the police métier has a telos, a purpose to pursue, or purposes: the reproduction of order, the making of crime, the managing of risk, and the governance of insecurity. In this slide, I'd like to take you, my audience today, through a little bit of a history of the technological innovation in the police organization. I think that technological innovation is the motor of organizational change within police institutions. This is obviously a very long and complicated history, and I'm going to simplify quite a lot for my purposes today. At the beginning of the 20th century, police patrolled their beats on foot. At that time, police communicated in their organizational structures in a centralized fashion, and police patrolled their beats according to a fixed, what they called a fixed point system. Sometime in the middle of the 20th century, that way of organizing was transformed significantly by the introduction of radio dispatched police car patrol. Now, when that technological innovation took place, it was viewed as highly progressive, very modernizing, and all good. It wasn't until 20 years later that police sociologists realized that there were some unforeseen and negative consequences. Put simply, when police patrolled their beats on foot according to this fixed point system, there were a variety of opportunities for them to interact with the public in non-adversarial ways, in reciprocal fashion, between human beings, as it were. Putting police in cars and mobilizing them on the basis of radio dispatch took away a huge proportion of those opportunities for non-adversarial contact between police and public. In a nutshell, they alienated police from the citizenry who they patrolled, and by increasing the amount of adversarial contact in proportion to non-adversarial contact, contributed to the delegitimation of policing and made police work harder, because police legitimacy is the cornerstone of successful democratic policing. The public must understand and endorse the police mission, and insofar as the amount of adversarial contact in proportion to non-adversarial contact increased, it undermined that endorsement and understanding of the police mission. Moving on in technological history, police organization has changed again in the adaptation of new technologies, and now we're at a point where police organization is networked and point to point, and is increasingly powered by surveillance technologies, which are getting to the extent that we can talk about ambient surveillance, surveillance which is in the atmosphere. everybody is always already under surveillance. And that is not just the citizenry, that is also the police worker themselves. Police work is amongst the most surveyed work that you can imagine. Police body cameras, police buildings with their internal closed circuit television systems, the constant monitoring of police work through their handheld computer devices. They're very surveyed people. And the public likewise is subject to ambient surveillance. We all are with our smartphones walking in public space, which is increasingly surveyed by a variety of techniques. These mediating technologies are between human beings. They are a institutional, instrumental expression and exaggeration of human alienation, contrary to the claims of Facebook and so on and so forth, that they're connecting individuals. Actually, the new social media are between individuals. They are separating, they are creating more alienation, and that too undermines the ability of civilians, the citizenry, to understand and endorse the police mission, because the imaginary, and maybe I read too much science fiction, maybe I shouldn't continually think of Aldous Huxley and George Orwell and Ira Levin and so on and so forth when I'm imagining the effects of the police world sociologically, but I do. And I have to say that listening to speakers in the conference so far today has done nothing to decrease my sense of unease. So anyway, police organization, police technology, my thinking connects techno-policing, the expression of what I think of as the newly emerging social order of technopoly, a concept that I borrow from the 20th century media theorist Neil Postman. Some of you will know from his landmark book, Amusing Ourselves to Death, which was a critique of the television age. I want to talk just very briefly about some of the effects of police technology on the subculture of policing, because in the new artificial intelligence, predictive policing world of advanced surveillance, communications, and information technology has created the illusion of total information awareness. Police stops, and Francois talked a little bit about police traffic stops and street checks, so on and so forth. Suspicion in those kind of interactions is now predicated on the illusion of this total information awareness. Police officers' own discretion has been reshaped. Their human ability to make reasonable judgments has been reconstituted by this illusion of total information awareness. And I quote the liberal political theorist Isaiah Berlin in saying that this idea of total information awareness, this idea that reality is wholly knowable, that knowledge necessarily liberates, and that absolute knowledge liberates absolutely, is erroneous and hubristic. Of course, law is never neutral. It is a folly to want law to be neutral in a democratic society. Democratic police can never offer freedom to the enemies of freedom. Nonetheless, the subculture of policing has been dramatically shaped by this new info structure that has been imposed on police organization, these advanced technologies, predictive policing, policing with big data, which creates this illusion of total information awareness when it really simply masks the ability of human beings to use good judgment.
James, I'm going to jump in and just mention that we're at time, but why don't I invite you to close and then leave some time for wrapping up some of the other stuff in the Q&A that we will have time for.
Thanks. I'll just say one quick word then about rule of law. Police have discretion to invoke the law. They use legal tools to get the job done. It's intrinsic to police work that they use discretion. The law cannot tell people what to do, as the phrase rule of law suggests. They must rule with law. Jean-Paul Brodeur, one of the most famous sociologists of police, talked about the impossibility of bringing everything police do under the rule of law. Egon Bittner and David Bailey said that whether we like it or not, police continually make judicial type decisions, deciding if invoking a legal statute is within the spirit of the law. In short, in a free society, police are above the law, but they are confined by the spirit of the law. In closing, I'll just say that the emerging techno-policing under conditions of technopoly is policing a post-democratic order. And here I'm drawing on the work of the political scientist, political theorist Colin Crouch, who argues that what is emerging in the 21st century is a kind of neo-feudalism where the technopolists, Elon Musk, Mark Zuckerberg, and the like, own the means of technological control, and the rest of us are subject to those controls. Thank you very much.
Thank you, James. And if it weren't obvious throughout so far, one of the things I'm just loving about this conference today is the range of different intellectual interests, topics, and strengths that are being brought to bear on the shared sort of core of the day around AI and benefits and risks. So another terrific session, James. Thank you. Now we're going to turn to Alexandra Scott and look at the topic of autonomous weapons systems and international humanitarian law. Alexandra.
Hello, my name is Alexandra Scott. I'm a PhD student at Osgoode Hall, and I had the great pleasure of being a Nathanson Fellow for my first 2 years as a PhD student. Apologies for asking this, but James, would you be able to stop sharing your screen? Thank you so much. I've got my presentation here, and let's see if I can just get it to present.
Great, looks perfect. I'll pop back up when it's time.
Sounds good. I actually need to keep it a bit smaller just because my notes are on the side. So my presentation is specifically on autonomous weapon systems and international humanitarian law. There we go. Off the top, I wanted to discuss some of the core principles of international human rights law. Now, on their face, they are very straightforward, so to speak. Human rights are universal and inalienable. as seen in many of the articles of the Universal Declaration of Human Rights. For example, Article 1, which says that all human beings are born free and equal in dignity and rights, and Article 4, which says that everyone has the right to life, liberty, and security of person. There's no differentiation based on race, sex, geographic origin, or any other factor. They're also indivisible, meaning that all human rights have equal status, irrespective of their zone of influence, be it civil, cultural, economic, political, or social. The denial of any one right impacts the full enjoyment of all other rights. They're simultaneously interdependent and interrelated. So the fulfillment of one right impacts not only the fulfillment of other rights, but it is often dependent on the fulfillment of other rights. For example, a right to education is likely going to be dependent upon the fulfillment of a right to clean water, to adequate nutrition, to a safe place to live. And lastly, they're equal and non-discriminatory, which is the universal nature of human rights. That no status, whether race, age, sex, language, sexual orientation, religion, political affiliation, nationality, disability, or social status, has a determinative factor on whether or not you are entitled to that right. Now, of course, for those who actually have practiced or are familiar with international human rights law, it's not actually that picture perfect in practice. But on its face, when you take a look at the commitments made under international human rights law, they are very straightforward and very easy to understand. If you were to model it as a decision tree, they would most likely approximate straight lines. Or it would, in that it would be, you would be going from unfulfilled to fulfilled. Now we get into international humanitarian law, which is less straightforward on its face. There are three core principles that I'd like to draw your attention to. First is the principle of distinction, which you'd find in Rule 1 of the International Committee of the Red Cross's Rules of Customary International Humanitarian Law. This requires that the parties to the conflict must at all times distinguish between civilians and combatants. Attacks may be only extended against combatants. Attacks must not be directed at civilians. And then there's Rule 7, which extends this requirement of distinction to encompass not only civilian objects, civilians and combatants, but also civilian objects and military objects, wherein civilian objects such as homes, hospitals, churches are safe from attack, and military objects such as bases, military installments may be subject to a lawful attack. But it's not that straightforward. Civilians, in the use of that principle of distinction, the term itself merely means persons who are not members of the armed forces. And the civilian population comprises all persons who are civilians. But there's another rule under international humanitarian law that provides that civilians are protected against attack unless and for such time as they take a direct part in hostilities. So while a civilian may enjoy this protection under international humanitarian law against being the subject of a lawful attack, depending on the actions they take, they may not actually be considered civilians for the full duration. And then there's necessity, which is essentially boils down to the fact that parties to a given conflict are limited to taking only those military actions that are necessary to achieve a given military objective. The point is that the attacks must follow the principles of distinction. You're not allowed to use indiscriminate attacks. You're theoretically not allowed to use a sledgehammer when a hammer would do. You need to use only that force which is necessary. And lastly is the principle of proportionality, which is somehow, it's difficult to describe exactly what I want to say, but I'll read the rule first. It's that launching an attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated, is prohibited. So unlike this first principle of distinction, which said that civilians may not be the subject of attacks, there's the rule of proportionality where they may be affected by attacks nonetheless. You cannot, under the rule of proportionality, direct an attack solely or primarily at a civilian object or civilian population. However, it is accepted that there will be collateral damage, and the requirement is not that there be no collateral damage, but that collateral damage be minimized wherever possible. So I'm going to jump a bit over to the ascent of artificial intelligence. So following a very vibrant period of science fiction, which some would argue began with Mary Shelley, the mother of science fiction, writing about artificial intelligence and being in her 1818 classic, Frankenstein, or the modern Prometheus. It was followed by Samuel Butler's Erewhon, which is also the name of a really high-end, overpriced store somewhere in the States. But it originated as Erewhon, a book published in 1872 that explored the concepts of artificial intelligence and machine consciousness. And then there was Fritz Lang's 1927 film, Metropolis, in which a humanoid robot or a robot with a human-like appearance is given the likeness of the main character's daughter, Maria. And then lastly, I, Robot was published in 1950, which is a collection of short stories by Isaac Asimov that dealt not only with the artificially intelligent robots of his creation, but introduced a series of laws known as the 3 laws of robotics, which remain influential in the field of artificial intelligence. So on the heels of this great age of science fiction came Alan Turing in 1950, who posited the question, can machines think, in his Computing Machinery and Intelligence paper. It was centered on that one question, can machines think, and led him to propose the Turing test, which rather than ask, can a machine think, he wanted to know, can a machine or a computer win a game? In that case, it was the imitation game, which is where can a computer behave in such a way that an observer, a third party, cannot differentiate the responses it gives from those of a human, and kind of kicked off this whole industry that artificial intelligence has now become. A mere 36 years later, you have NavLab, which was the production of the very first self-driving car, which was created by the Robotics Institute at Carnegie Mellon University. And then in 1997, Russian chess grandmaster and then reigning world chess champion Garry Kasparov lost a chess game to IBM supercomputer Deep Blue. He won the first game the previous year, or sorry, the first tournament the previous year with a score of 4-2, but then lost the rematch at a score of 3.5 to 2.5. Both were done best of 6, where a win counts as 1 point and a draw is done by mutual agreement, is worth 0.5. In the immediate aftermath of that Deep Blue win in 1997, after Garry Kasparov's loss, Dr. Piet Hutt, an astrophysicist at the Institute for Advanced Study in Princeton, New Jersey, said to the New York Times that it may be 100 years before a computer beats humans at Go, maybe even longer. Go being a different game that is considered far more complex than chess. If a reasonably intelligent person learned to play Go in a few months, he could beat all existing computer programs. You don't have to be a Kasparov. And that was when AI experts set their sights on the next challenge. Pictured on the slide is Effoduh, a 9th Dan ranked international player of Baduk, as it's known in Korea, or Go. He took on the challenge of playing an AI system called AlphaGo in 2016. Of the 5 matches he played, he won only 1. And it's hard to overstate just how incredibly complex Go is. It's a 19 by 19 grid versus 8 by 8 for chess. So where chess has 16 pieces aside, Go is played with 181 black, 180 white pieces. So the number of approximate board moves you can make after 4 moves in chess is approximately 1.5 million. In Go, the number is approaching 1.6 billion. If you do just one more set of moves, there's 1.8 billion possible outcomes for chess. In Go, it's 64 trillion. So it was considered the pinnacle of AI. They didn't expect that it would happen within a century, but then it did in 2016. And it was made possible by a deep neural network, which allowed AlphaGo to not only evaluate millions of games performed by the world's top ranked Go players, but it also allowed it to play a modified version of itself and gain firsthand experience and learn like a human would, overcoming the thing that all AI experts thought would be the limiting factor, which is the humanity that they believed would be required to play it. And then most recently, we have the Kargu 2. This is an image of the Kargu 2. It's produced by Turkish weapons manufacturer STM. In March 2020, there was a skirmish between 2 forces in Libya, those aligned with the UN recognized government of national accord, and those aligned with the Libyan National Army, which is led by General Khalifa Haftar. The SM-2, according to a UN report, was used to subsequently hunt down logistics convoys and retreating forces that were aligned with the General Khalifa Haftar, using not only the autonomous weapon systems such as the STM Kargu 2 and other loitering munitions. And they were programmed to attack targets without requiring data connectivity between the operator and the munition. In effect, a true fire, forget, and find capability. And that is where we stand now in terms of artificial intelligence. We have artificial intelligence that is capable of beating the unbeatable game, a game that people believed only a human could play due to the vast amount of pattern recognition and innate sensibility that is required of a Go master at the 9th Dan rank, such as Effoduh, and weapons that are being currently deployed around the world, including in Ukraine and Gaza, where US weapons manufacturers have used both conflict situations, essentially a live testing operation. But what is the problem here? Is that we have 4 AI models. Most AI has focused on the study and construction of agents that do the right thing, which is a rational agent. And that requires that an AI model act rationally, not necessarily humanly, in the face of a given conflict. But the problem that exists in all of this is the bounded rationality and the inherent complexity of those fundamental principles of international humanitarian law that I reviewed earlier. If a computer were to calculate every possible outcome of the Go match that was being played between Effoduh and AlphaGo, it would have taken far longer than tournament time rules would have allowed. So as a concession, the Go match, AlphaGo limited itself to the 10 million most likely moves. According to The Economist, the version of AlphaGo that Effoduh played against had 1,920 standard processor chips, or CPUs, and 280 special ones developed originally to produce graphics for video games, more commonly known as GPUs. So it required a substantial amount of processing power in order to just play those 5 games against Effoduh. And Effoduh won the 4th match, not because he outsmarted the computer, but because of his humanity. He placed a stone that AlphaGo could not, it didn't come up in that first 10 million possibilities. It was not one that AlphaGo contemplated a human playing under those circumstances. He played a 1 in 10,000 move. And so when we think about how all of these programs that we've been discussing today, be it in the context of copyright, these generative AI processes, and now in terms of the AlphaGo software, These are essentially closed systems. They are receiving an input from a third party, and then they are drawing on their total knowledge that they have derived, be it from humanity, by viewing Go matches, by reading or quote unquote reading, scanning, interpreting, compiling the text of various novels. They are closed systems, and they are still requiring an exceptionally high amount of input, computing capacity to produce the best results. And they still can't foresee things like that 1 in 10,000 move. But what about in a situation like a war, where it's not a closed system? There are people acting humanly everywhere around them. That is the primary concern I have about artificial intelligence. It's not that there will be a maliciously programmed killer robot, but that you can do everything in your power to program an artificially intelligent weapon system or autonomous weapon system or a killer robot, and that it simply will not be able to process and adequately respond to things that humans can and do, and that the rules that we have that govern the interactions in wartime, these laws of war, they're simply too human to be distilled into a way that a robot would be able to function lawfully. And that is the problem of bounded rationality, is that it's too complex a calculation. So rather than seek the correct answer, those programming the robots would have to instead try and get the best answer. But the best answer is so highly situational that I fear that it will not actually follow international humanitarian law in all cases. Thank you so much for your time.
Thanks a lot, Alexandra. I'm now just I'm conscious of the time, so I'm going to switch gears right away to Dr. Anthony Sangiuliano, and who's going to look at approaches to prohibiting algorithmic discrimination under the Canadian Human Rights Act. Anthony, over to you.
Thanks so much, Trevor. So the plan of my talk today is going to be to try and establish 2 claims, which is the first of which is that Canada's proposed Artificial Intelligence and Data Act, it requires us to consider how best to prohibit algorithmic discrimination or discrimination by predictive machine learning systems under the Canadian Human Rights Act, the CHRA. And that's the first claim. The second claim is that indeed we can prohibit discrimination under the CHRA, and we need only invoke some familiar principles of anti-discrimination law to do so. And I want to say that we could do that despite there being some gaps in coverage that emerge from this new form of discrimination. So to get started, what I want to do is put on the table a what I think is a simple understanding of the way in which the proposed AIDA addresses algorithmic discrimination, or what it refers to as biased outputs of artificial intelligence systems. And what the Act does, or proposes to do, is impose certain duties on persons responsible for AI systems to mitigate the risks of what it calls biased outputs. And so persons responsible that it applies to include people like developers, designers, purveyors, people who make available artificial intelligence systems, or managers of artificial intelligence systems. And it imposes a variety of duties on them, duties including one to enact mitigating measures within one's organization, measures that mitigate the risks of bias output that could result from artificial intelligence. And so there are many other forms of duties. I think that this duty to adapt mitigating measures is one that is at the forefront of the way in which the Act addresses biased outputs. But we need to know what a biased output is, and the Act defines a biased output as an AI prediction that disadvantages an individual directly, this is a paraphrase, directly or indirectly and without justification because of a prohibited ground of discrimination in Section 3 of the Canadian Human Rights Act. And so here's pretty much a paradigmatic example of algorithmic discrimination, a case involving mortgage lending. You might have a bank who deploys a machine learning prediction of lower creditworthiness for Black applicants for mortgages by relying on proxies that correlate negatively with the ability to pay back a loan in the future, such as proxies including levels of previous income or levels of health, which correlate negatively with an ability to pay back a loan. And if these proxy traits are possessed disproportionately within the data that's mined to generate the prediction disproportionately by Black persons, as we know, due to prior structural injustice and discrimination, then the prediction of lower creditworthiness and less mortgages ultimately and homes ultimately being given to Black applicants as compared to white applicants compounds that prior injustice. It carries it into a new domain and perpetuates it. That's the problem of biased output, or at least one example of it. And there's a duty to mitigate it on those persons responsible. The Act imposes a variety of kind of enforcement mechanisms in order to enforce the duties it imposes. Mainly, they involve ex-ante deterrence. They're forward-looking. They say that we're going to impose certain consequences for a breach of the Act that are forward-looking in the sense that they're designed to deter that conduct from happening in the future and ultimately transform and change certain norms and practices involving the application of bias AI with biased outputs. So, for example, Section 29 involves the imposition of administrative monetary penalties for a breach of duty. And in Section 29, it explicitly says that the purpose of this permission is not punitive, but to change future conduct, obviously to avoid charter problems about retroactive laws under given Supreme Court decisions. But Section 30 imposes strict liability offenses coupled with a due diligence defense. And as we also know about these enforcement mechanisms, they're also meant to be non-punitive, but meant to change future conduct as well. So it's about ex-ante deterrence and hopefully preventing biased outputs from happening in the future. In fact, the kind of ex-ante nature of the regulatory structure of the AIDA is made even more clear by the fact that the minister in charge, Ministry of Industry, or whoever else gets delegated, can issue cessation orders almost like an injunction for AI systems that are of a serious risk of imminent harm, even before that harm materializes. So it's all about preventing and deterring future biased output. And I should mention here that not all of anti-discrimination law works this way. In fact, it's kind of unique, maybe as opposed to the Genetic Non-Discrimination Act, which is punitive, criminalizes genetic discrimination. Most anti-discrimination laws offers ex post compensation. And in my previous work, I've actually argued that ex-ante deterrence is the proper way to deal with the issue of discrimination, in particular, the systemic harms and collective harms that it causes. However, you might think that this is, and those who disagree with me might push back on that view and say that what we're missing out is an important aspect of anti-discrimination laws compensating victims or providing victims with some kind of recourse or remedy. Not just, so this, it's backwards looking. It's recognizing the existence of harm and trying to make the victim whole, or vindicating the rights of victims, and in that way achieving a form of corrective justice, correcting the wrong that they suffered. So although the AIDA doesn't primarily focus on compensation, it does kind of invite us to think about the possibility of compensation, because under Section 26(1)(b), the minister, who is empowered under the Act to say do things like collect information through audits about the operation of AI systems, can disclose information to the Canadian Human Rights Commission, as well as a bunch of, under Section 26(1), a bunch of other federal agencies. What B refers to the Human Rights Commission if there are reasonable grounds to believe that a person has contravened the Canadian Human Rights Act. So the purpose of that disclosure of information is to enforce the Canadian Human Rights Act. And one of the remedies under the Human Rights Act, if that information comes in the hands of the Commission, is to offer compensation for pain and suffering, Section 52(3)(d), for a breach of the Act, for discrimination, and potentially, therefore, a biased output of artificial intelligence. So the first claim that I wanted to make is that this kind of invites us to think about how it is that the Canadian Human Rights Act prohibits algorithmic discrimination or remedies it. And here, I think we encounter some challenges and potential skepticism about the ability of the CHRA to do that. And the thought that our existing legal principles for proving discrimination for a victim are inadequate. So here's Teresa Scazza in a recent article in Canadian Bar Review commenting on the AIDA. And here she's really kind of referring to American literature on the regulation of AI. But she said there will be significant challenges in litigating harms caused by AI systems. It will be difficult to prove causation. For those of you familiar with recent developments in Canadian anti-discrimination law, the issue of causation and the difficulty of proving it is very much at the forefront. Difficult to prove causation, the complexity of both algorithms and data mean that litigation will be complex and enormously costly. So what SCAS is pointing to here is that the kind of obvious technological complexity involved in understanding how it is that AI systems, machine learning generates its predictions. Not only that, what's called the opacity or the inscrutability of the systems, that is to say, lack of knowledge about how it is that it sometimes decides on proxy traits in order to generate statistical correlations and predictions, make it very difficult to prove a violation of the Canadian Human Rights Code and ultimately achieve a remedy for victims to do that. So this is the skepticism that I want to push back on and suggest that things are not as dire or dystopian as they might appear. And to do that, I want to briefly think about two forms of discrimination, direct and indirect, which should be familiar in the Canadian legal landscape. Direct discrimination we can understand as the intentional use of AI with a biased output. You can imagine a programmer intentionally selecting certain proxies that are known to correlate negatively and disproportionately disadvantage members of protected groups. Or indirect discrimination is the use of AI with an unintended disproportionate impact on those protected groups. So you might think it's so hard, it's going to be so hard to prove that AI was intentionally programmed to have a biased output. And the same thought has come up in just being able to prove the intention of a respondent when it comes to establishing a direct discrimination claim. And to alleviate the burden on claimants in this respect, there's an evidentiary burden shifting framework, which is nicely discussed by the Ontario Court of Appeal in a 2013 case called Peters. And under this framework, it's not necessary for a claimant to show direct evidence of the discriminatory intent of the respondent. They can instead show circumstantial evidence that invites the trier of fact to infer something about the mental state of the respondent. If they can do that, the burden shifts to the respondent to give some kind of non-discriminatory, innocent explanation for what appears to be the circumstantial evidence triggering that kind of inference. And if they succeed in providing, or if they're able to provide a innocent explanation, the burden shifts back to the claimant just to rebut that explanation and say that it was a pretextual one. And ultimately, the trier of fact is asked to draw a conclusion based on these shifting burdens. And it seems to me that when it comes to prohibiting direct discrimination that proceeds through the programming of AI, that same sort of burden shifting framework should be available. And although there may be specific difficulties in proving that, the same sort of structure of that's already established can be modified or adapted to deal with this new problem. So what about indirect discrimination? Direct discrimination, thankfully, is less common, and what we're worried about when we think about modern algorithmic discrimination is systemic discrimination, non-intentional discrimination embedded in our practices. And here you might think, well, it must be super difficult to prove that. And as a matter of fact, the Supreme Court of Canada has stated that when it comes to proving indirect discrimination, the burden on the claimant is actually surprisingly light. So a biased output of an AI system just is a disproportionate impact on members of certain groups. So if you think about the mortgage lending example, just the fact that fewer Black applicants are given mortgages because of their predicted creditworthiness as compared to white applicants is enough of a statistical disparity of an AI system such that if it can be proven using statistical evidence, the claimant will be able to discharge their burden, generally speaking, under human rights litigation. And so the Supreme Court of Canada, borrowing from British jurisprudence, has said that there's no need for the indirect claimant to explain the reason why there's a disparate impact. And so if we think about how, if we believe that the proxies and statistical correlations used by an AI system are just so difficult to access and break open that black box, it's just not necessary for the claimant to be able to show that to discharge their burden. And that's pretty kind of firm. There's pretty firm jurisprudence on this point, and again, seems readily adaptable to the algorithmic discrimination context. If the claimant can discharge their burden, the burden shifts to the respondent to justify the biased output. And here's where I think some gaps in coverage in our existing anti-discrimination principles emerge. The respondent's burden is to show that the impugned system is rationally connected to a legitimate aim that they have and is necessary, in that there's no alternative that would achieve that aim better. So it's kind of a proportionality analysis. In the UK, it just is called a proportionality analysis. There's two sort of things that might complicate this traditional way of understanding the respondent's burden. The first is what has been called a feedback loop, which is that given enough time to operate, an AI system with a biased output could actually, over time, reinforce its own rationality. So a respondent who's trying to justify a biased output will say, well, the predictions it generates are just so accurate and uncover such strong statistical correlations that it just makes so much sense for me to use it in my system despite the disparate impact that it has. And so what will happen if it keeps getting used over time is that the biased output that it generates may function as new input, new data set to be fed back into the system to generate even stronger predictions about the correlation between the proxy traits it identifies and the ultimate predictions the outcomes that it predicts. This has been called a feedback loop. So over time, even though it has a biased output, if it keeps getting used over and over again, it kind of bootstraps, reinforces its own rationality over time. And this may be a specific problem with the use of algorithms that we will need to address in order to, maybe a gap in our existing principles that we need to address. And that gap is favorable to respondents, but there's another gap that's not favorable to respondents, which is that the proxies used to generate a prediction, if they're unknown, it makes it very difficult for respondents to be able to show that it's necessary, because they're unable to demonstrate alternatives to something that they don't know how a proxy works. They can't demonstrate alternatives to it that work better. So that kind of aspect favors respondents. So to bridge the gap, there is a provision under the AIDA concerning regulations that the Governing Council can make to, for example, clarify how justification works. And this is where we may need new principles to address algorithmic discrimination. But my main conclusion is this, that I think that certain worries about the revolutionary upheaval of algorithmic discrimination for existing legal practices might be a little bit over-exaggerated. So we should keep calm and carry on and try our best to apply our existing practices and principles, identify and address gaps in them in a way that adapts to these new technologies. Thank you.
Anthony, thank you very much. Not just for the wonderful presentation, but also the perfect timing. I'm now going to switch gears again and pass it over to my colleague, Nye Thomas, who runs the Law Commission and who's going to look at regulating police facial recognition technologies, issues, and options. Nye, great to see you. Over to you.
Thank you, Trevor. I'll start by saying I don't have slides, and I'm going to try to be quick in light of the time. Let me tell you a bit about the Law Commission. We are an independent law reform research institute located at Osgoode. As some of you may know, we've done a lot of work in the last couple of years around regulating AI, particularly in the public sector. Our concerns in this work really are how you ensure human rights, how you ensure due process, how you ensure access to justice principles in public AI systems. We're currently running two projects, which I'm going to talk about briefly today. One is we're working with the Canada Human Rights Commission and the Ontario Human Rights Commission to develop an AI human rights impact assessment. Secondly, more to the point for this project, this presentation, we're doing an AI life cycle, criminal justice life cycle project, which looks at the use of AI and algorithmic technologies throughout the life cycle of the criminal justice system, with a view to try to identify common issues, common themes, common regulatory priorities. So I'm going to keep my remarks short. I'm talking about, as Trevor says, I'm talking about how you regulate police facial recognition systems. And this is going to be a high-level discussion. I'm going to talk a little bit about the technology. I'm not going to talk so much about this discussion also covers several jurisdictions. So not all the systems and issues I'm going to talk about are relevant or have arisen in Canada yet, but we can see them coming. And I think they're important to know for regulatory purposes. So as I say, I'm going to try to keep it short. And in fact, I'm going to try to distill my remarks down to 3 points. Point number 1, police FRT technology is here and it's moving fast. The technology has been used by police services in the United States, Europe, Canada, depending upon how you count, maybe 10, 15 years at this point, used in a variety of contexts. The reason police use it, which is not discussed that often, is it's used to, these are the objectives they identify. It's used to promote public safety. It's used to promote officer safety, an underappreciated value in policing work. It's used to meet operational needs and to improve operational efficiency. So a lot of the same justifications that we see when you talk about AI in the public sector or anywhere else for that matter. The most common use is using FRT as a using face identification as part of an investigation. And it generally works like this. Police have an image called the probe image of a suspect or someone else. And the FRT system takes that probe image and matches it to a database, an image database, which is called the reference database. And then the FRT system, the code, makes a prediction about that image, who it is, what their characteristics might be. And in so doing, that prediction can become an important tool to identify suspects, witnesses, missing kids, all different kinds of people. And that information is then used to assist in a police investigation. Depending upon the system, depending upon the jurisdiction, there may or may not be a police officer in this chain. There may or may not be a trained FRT technician in this chain. There may or may not be a warrant requirement in this chain. It really depends. There's no single cookie cutter approach to this stuff. There are a lot of choices. Potential uses of this technology are quite broad, as you can well imagine. It can be used to identify or try to track specific individuals. It can be used to try to attack categories of people. It can be used for serious crimes, sometimes used in traffic stops. It's used to police protests. It can be used in specific investigations or for mass generalized surveillance. It can be used for trying to assist investigations where the alleged crime occurred some time ago. It can be used for real-time surveillance. So something is happening right now, or in some of its iterations, it could be used as a crime prevention tool as well. Now, the potential source of the images can be very broad, as you may well imagine. It could be a public security camera. It could be a private security camera. It could be a drone. It can be a police body camera. It could be a camera in an ATM. It can be a camera in a mall. It can be a camera in a home security system. Really, the images can be captured from just about anywhere. And as you will know, that is one of the ongoing issues and risks about AI systems, about FRT systems, and I'll get to that in a moment. Similarly, the reference database. So you've got the probe image and you've got the reference database. That can come from anywhere too. People may be familiar with the Clearview AI example. That's technology that scraped images off the internet and used that to track, to compare these probe images. More common use is to compare probe images to mugshot databases or for police specialized databases, maybe around child trafficking, missing person, and the like. But it really could be anything. A lot of jurisdictions actually allow the use of FRT systems, police FRT systems, to compare these probe images to driver's license photographs, potentially, covering just about everyone, or at least all adults in a jurisdiction. And generally speaking, what FRT regulation tries to do is it tries to cover kind of the breadth and depth of these different applications and uses and contexts, which, not surprisingly, from a law reform perspective is quite a tall order. That's my first point. Point number two, there's actually a lot of experience with police FRT systems, and we know most of the risks are generally well known. As I say, systems have been used for 10, 15 years now, so we can consider them to be new, but not brand new. A lot of experience in a lot of different jurisdictions of how they work in practice. It's not theoretical, it's not abstract. They have a track record. Most of the risks you'll be familiar with, but they really come down to three main ones that people know about and talk about a lot. First, there are reliability and bias risks. So there's a risk that predictions are unreliable. Systems have proven to have a lot of problems making accurate predictions about brown and black faces around women. So because of these reliability and prediction and bias problems, there's a risk of misidentification of suspects, risks of misarrest of suspects, over policing of racialized or low-income communities, indigenous communities, which effectively worsen the existing biases in the criminal justice system. The other risks that people know about, talked about a lot, are risks around privacy and surveillance, resulting from how images are captured and the databases that are used for comparative purposes. There's a risk of mass surveillance. There's a risk of personal tracking, significant privacy violations, risks to rights to free association, risks to right to protest if you believe that your image is being captured by a police service while you're out of protest, things like that. Finally, some people have talked about these risks so far. There are a lot of procedural risks with FRT system. It's the black box, the lack of due process, lack of disclosure, questions around FRT as evidence, questions around explainability of systems and the like, all raising very serious questions about how you ensure due process in the consideration of these systems. These are kind of the well-known risks. I want to identify two more that I think are particularly relevant in the criminal context. One is what might be called the access to justice or contestability risk. Imagine you're a criminal defendant. Imagine you're facing some kind of a charge in provincial court. Imagine you're low income. Imagine you're on a legal aid certificate. Imagine you're being represented by duty counsel. Imagine you're self-represented. How in the world are you supposed to be able to practically challenge a piece of evidence that was used to lead to the charge against you? Just think of the issues. You've got data issues. You've got the reliability issues, potentially hundreds of thousands or millions of lines of code. There's complex statistic modeling. There's risk scores and the like. You've got the black box. Very, very, very challenging. It is so much more complicated than something like challenging a breathalyzer. And for most people, represented or not, most people in provincial court facing these charges, it's simply impossible. You will not be able to challenge. An important piece of FRT evidence for the case against you. And what, of course, that does is it means that only the best funded, best prepared, most lawyered up litigants, criminal defendants, really have a reasonable opportunity to challenge these systems. And of course, that dynamic, that access to justice challenge, just compounds the existing problems with bias and reliability and the over-policing of low-income, racialized, and indigenous communities. So it has a real potential to make existing criminal justice problems worse. The other challenge, the other risk that's not really talked about, but is very real, is something the Law Commission calls the compounding technology risk. Again, other people have talked about this today. But FRT systems are not the only new technology that's being used in criminal justice and policing. You've got predictive policing. You've got voice and sound recognition systems. You've got algorithmic risk assessments used for bail or sentencing, location tracking. You've got new forms of AI-aided DNA evidence. You've got other forms of AI-generated evidence, all of which just make the complexity of criminal justice and of defending yourself in a criminal proceeding so much more complicated. It won't surprise you that a lot of the same issues that arise in FRT, a lot of the same risks in FRT systems are replicated in these other technologies as well. Bias, complexity, the black box, lack of remedies, lack of due process. So there's a risk that on the one hand, either we focus our regulatory efforts on FRT and we don't deal with these other issues, which, in the context of a criminal prosecution, criminal proceeding may in fact have a greater impact on your liberty or not. Or there's a risk that the criminal justice systems becomes overwhelmed with technology, and the lawyers and the defendants and the judges and the policymakers simply become overwhelmed by all the technological change, and as a result are incapable of making it work as well as it should and dealing with issues appropriately. So this sort of brings me to my third point. I'm going to talk about regulation, and it's really this. Just like there's a lot of experience with facial recognition technology, similar systems, a lot of jurisdictions across North America, Europe. We also have a lot of experience with FRT regulation. And in fact, the elements of thoughtful FRT regulation are well at hand. We kind of know what they are. Before we get into some of the details, however, I'm going to start with some general comments. First point is that there's a lot of FRT regulatory stuff on the books right now in different jurisdictions. In the United States alone, there are probably 25, 30 different statutes that regulates police FRT in some way, shape, or form. There's the EU AI Act, which has been talked about today. There's very thoughtful guidance on privacy considerations from the Canadian Privacy Commissioners. There's, in fact, very thoughtful police policies developed by Interpol and organizations like the Toronto Police Service. There are emerging technical standards. There are a lot of ethical AI frameworks. There are AI impact assessment tools, such as the one being developed by my organization. So in fact, there's a lot of stuff that's been done already. We aren't coming to this issue fresh. Second point I want to make about FRT regulation, which is really a point about tech regulation generally, is that we should start by regulating the risks and rights that we know about. There is a tendency when we talk about tech regulation to kind of go to the most complicated scenario. My organization's been in dozens and dozens and dozens of conversations around tech regulation for the last couple of years. And 9 times out of 10, in the first 5 minutes, particularly in the last year, people say, well, what about ChatGPT? What about generative AI? And they kind of go to the, what in my view is the most complicated problem, as opposed to starting with the risks that we know. And from a law reform perspective, and from just a practical policy perspective, in my view, particularly with respect to FRT regulation, we should deal with the risks that we know in the first instance: mass surveillance, privacy issues, due process issues, lack of remedies, bias. There are ways to tackle these topics. Final point I want to make, not my final point, my penultimate point that I want to make, is that the level of regulation has to match the level of risk and rights at issue. Criminal justice system, we're talking about liberty, due process, human rights, bias, public order. These are fundamental issues, and the level of regulation should match it. And that means general AI regulation like AIDA doesn't cover it. Policing policies don't cover it. General privacy legislation don't cover it. They simply aren't comprehensive enough. They aren't enforceable enough. They aren't democratic enough. So what are some of the options? Well, again, surveying some of the existing regulatory models that are being used in a bunch of different places. On the one hand, we can prohibit certain forms of technology. That's what the EU AI Act does. It prohibits real-time FRT use in public spaces, subject to some important and rather wide exceptions. There's a way to, some jurisdictions have talked about prohibiting the use of FRT in drones or body cams because of the surveillance potential. There are moratoriums. Many jurisdictions have effectively said that timeout. We're not going to allow certain forms of FRT pending a review, pending new legislation. Using the precautionary principle to say, we have to think about this a little more closely before we charge in. The Canadian Civil Liberties Association and several other organizations are in fact making a big push in this regard in Canada right now. It seems to me that that's a good idea. And then, of course, there's kind of operational oversight legislation dealing with disclosure, warrant requirements, purpose limitations, disclosure obligations, testing evaluation, and the like.
Now I'm gonna push you to wrap up and then invite you with the balance in.
Okay, I've got one more point, then I'm done. Thank you, Trevor. It's Law Commission. We've thought about this a lot. Our basic view is pretty consistent with a lot of other proposals on FRT regulation. At a minimum, FRT regulation has to include explicit statutory authorization. There have to be purpose limitations, perhaps prohibitions. There have to be disclosure requirements, procedural requirements, remedial provisions, and oversight and testing and public reporting requirements. And last, and certainly not least, governments and others have to convene a process which all stakeholders, police, governments, policymakers, academics, communities, people who are subject to these systems, come together and talk about these issues openly and thoughtfully. Doing this stuff either in an ivory tower or behind closed doors is not sufficient. And with that, I will conclude. Trevor, thank you.
Great, Nye, thank you. And thank you, everyone. So I'm going to invite our panelists all to join us if they're able with their cameras on to come back. We've got, the panel ends at 4:30, so we do have still a good chunk of time. And I'll invite our audience, if you do have any other questions. We've just got a couple of things in the Q&A, and I'll start, Sean, with you. There's a question. Did you use ChatGPT API or ChatGPT web version to do this? Are there any other AI tools for deep legal research that you recommend? Maybe, Sean, I'll throw it over to you.
Yeah, well, thanks for the question. So I did this in November of 2022, so it was before ChatGPT. But I did use OpenAI's API with an older model, the ADA version of GPT 3.0. If I were going to redo this today, there are open source models that are equally performant and less ethically problematic than models connected with OpenAI. As for tools that you can use to do research in this area, my view is that the best way to engage with leveraging AI, generative AI, and other forms of AI is to do so directly using very simple code in Python. I'm teaching a course right now to law students at Osgood that teaches students how to do so. You can learn how to do so in 10 hours in order to be able to engage with APIs effectively for the purposes of legal research. So that's what I would encourage. There are commercial offerings out there, but I think being able to get your hands dirty and work with the code yourself is probably the best option right now.
Great, Sean, thank you. And I should have said that question came from Jennifer. We've got a question from Christina. I'm not totally sure who this, so I'm going to open this up a little bit. Is there also a duty to use balanced data set based on algorithm that was built on and some transparency or explainability duty to explain the process of making the decision? It could be a good example of how to mitigate the risk that can occur in output. Similarly, such duty is imposed in case high-risk AI systems according to the EU AI Act in the similar context. I'm not going to invite everyone to give a full answer, but I know this touches on essentially everyone's talk. Does anyone want to quickly jump in?
I'm happy to speak to that, Trevor,
Sure,
because of
Anthony.
this idea of mitigating can come up as one of the duties under the AIDA. To speak to one component of the question, there is another duty under the Act for persons responsible to publish online on a website a plain language description of how the algorithm works and what purposes it's being used for, and what other measures are in place to mitigate the risk of biased outputs. So this goes to the point of transparency and the point that Christina asked about explaining the process of making the end decision. And yeah, I agree that could be one option to be able to mitigate the risks of AI, just making it more transparent and public, right? Corruption thrives in the dark. So bring it out into the light and be able to have some scrutiny.
Great. Anthony, thank you. Anyone else want to jump in on any part of that? Okay. I'm going to go to our next question from one of our students, Sophie Sklar. Great to Sophie. Here I'm going to read your question. Thanks all. This is directed to anyone that would like to answer. In Professor Chaudhry's Corporate Social Responsibility Seminar, we have been talking about the best ways to ensure human rights compliance by government actors. With the introduction of AI and these technologies that impact human rights, as you all have mentioned, what, in your opinion, is the best step forward to government and ensuring human rights compliance with utilizing AI by government actors? Domestic laws like the AIDA question, international declarations, external stakeholders like monitoring groups or NGOs. Thoughts maybe from a couple of you. I don't know, Jake, whether you had any thoughts on that one that you wanted to jump in on.
Yeah, I could. I don't think we have a silver bullet in terms of what can be done. I think it needs to be a lot more pluralistic. For example, if you look at the AIDA, which is very, very, very limited to only high impact systems, is also limited to interprovincial or international sort of trade and commerce. It also makes the point about sort of promoting global capital and promoting industry as opposed to sort of protecting human rights. It's a risk-based like regulation. It's not really human rights based, even though it has some of those human right languages into it. So there is some value that the AIDA will provide, but it might not really deal with solving the harms that that AI systems will perpetuate, right? So even when we look at the international system, there is only to a certain extent that corporate entities are held liable under the responsibility to respect human rights, as opposed to states' responsibility sort of to protect human rights. And so I think we need a pluralistic approach to it. We need to ensure that laws, both internationally as well as domestically, even provincially, have sort of avenues to ensure that we address the human rights harms from AI systems, including internationally, because it doesn't make sense if we say, oh, people can't use AI to perpetrate human rights abuses in Canada, but those same people can just sort of take a flight and sort of do the same thing abroad. And I think the last point to recognize is that AI is a deterritorial technology. No state can adequately like govern or legislate on AI from a domestic approach. You know, these AI systems are pretty much built in different jurisdictions. The chips could be from Taiwan. It could be hosted somewhere in China or India, and the developers could be right here in Toronto. So there's no AI system that is purely just domestic and thrives in that terrain. So the AIDA, not like looking at AI systems that are built by law school or saying that they would not sort of apply to AI systems that are designed only for a particular territory or are designed for nonprofits, is quite weak, and you know, it doesn't serve much. So I think there needs to be at every single level of of compliance, every single level of authority, that we have laws that are able to cater to these human rights harms and abuses.
Great. No, thank you. And maybe I'll give, I'm just conscious of the time. Alexandra, I know some of the themes came up directly in your paper. In sort of a minute or less, anything that you wanted to add to what Jake, or about this question around notions of governance?
Yes, thank you. Just to build off what Jake so eloquently said, is that there are some concerns as well, specific to the autonomous weapons, that there will not be some sort of international cohesion on what approach to take. Some states are very much opposed to the development of autonomous weapons systems. Similarly, there's been a significant push from various groups, such as the Institute of Life. It's very much contingent upon cohesion on what is the right way to fight war. And unfortunately, when it comes to arms races, people are always going to want that edge, especially in the aftermath of, for instance, the invasion of Ukraine. A lot of people are saying, well, that is what happens when you give up your access to nuclear weapons. These are the potential threats that you're inviting down the road. So there has been a bit more of a pushback against potentially giving up additional ways to defend yourself. So while I do have hope maybe down the line we might see some kind of international collaboration and regulation, I think that it's potentially going to have to, the most promising, I guess, commitments would likely be in the more domestic sphere, if anything.
Well, I know that, thank you for that. And I know that everyone will have comments. I'm going to take the chair's prerogative to end on that note of somewhat hope. And I'm going to add, just because we actually truncated the break last time, I'm going to add a minute to this break. I don't want to shorten it. So I'm going to end this panel simply by saying thank you to all 6 of you for really interesting, engaging papers on such a range and breadth of topics. So thank you all. We are now on break, and we will start with our third and final panel at 4:45, if I have the time correctly. So until then, thanks everyone.